Hey everybody, how's it going? Welcome back to Copper Jacket TV. So every once in a while, I'm at a loss for words, and that's kind of how I feel today. We have a federal district court judge in the state of California that has just upheld California's ban on so-called assault weapons, and her reasoning is just as absurd as you could possibly imagine. So let's talk about what happened. Okay, so let's go ahead and talk about what's going on here. So we're talking about the case of Rupp v. Bonta, which we've talked about on this channel in the past. If you're new here, hit that subscribe button, that little bell notification. That'll let you know when new videos like this come out and you can stay on top of this stuff. So Rupp v. Bonta has actually been around for quite a while, and it challenges California's ban on so-called assault weapons. As a matter of fact, this is its second go-around now. The judge that we're talking about today, who is clearly an activist, hates the Second Amendment, is willing to ignore the Constitution and the rule of law and twist the words in Bruen, is going to be Judge Josephine Staten. Now, the first go-around for this case was pre-Bruen, so before the Supreme Court's Bruen decision, this case was heard, and the judge at that time sided with the state of California. Now, it got appealed up to the Ninth Circuit, but the Ninth Circuit decided to sit and wait until the decision in Bruen before it actually made any moves. Now, after the Bruen decision came down, the Ninth Circuit decided that they were going to reverse the district court's decision and remand it back down for a second look. Now, post-Bruen, we have some different rules that the court needs to follow. If the text of the Second Amendment is implicated, the burden shifts to the government to prove that there is a historical tradition of regulation dating back to 1791, the ratification of the Second Amendment. Now, the judge in this case decided to twist a bunch of words in Bruen, change things up, and kind of go with the whole in common use for self-defense thing. We've seen that argument a lot. So the actual test is common use for lawful purposes. If they're in common use for lawful purposes, then they are protected by the Second Amendment and you can't ban them. Well, judges across this country, district court judges, appellate court judges, have decided to kind of change that and say, well, if it's in common use for self-defense, then it would be protected. But this judge decided that, well, you can't necessarily prove that these are in common use for self-defense. The numbers are extremely low, and therefore that's one reason why they are not protected by the Second Amendment. But another reason is because that she considers them to be dangerous and unusual. Now, when it comes to dangerous and unusual, which is something that we got from Heller, it can't be something that is either dangerous or unusual. It has to be both. Now, we know that these things are absolutely not unusual. There's tens of millions of them owned by tens of millions of people across this country, which makes them fairly usual. And we know that they're used mostly for, lawful purposes, right? So clearly the Second Amendment is implicated, but this judge doesn't believe that that's true. She believes that, well, they're not in common use for self-defense, and they're both dangerous and unusual. Now, the judge in this case actually cites the Fourth Circuit. So we all know that they're not unusual, right? Like I said before, there's tens of millions of them owned by tens of millions of people. They're not unusual at all. But she's citing the Fourth Circuit saying, well, do we really know if they're unusual? Because, I mean, how do we look at it? And again, she cites them here where it says, other courts of appeals have expressly noted that the undeveloped nature of the inquiry into a weapon's commonality. The Fourth Circuit listed several questions that highlight the analytical differences. So this is where they're just really trying to break things down and read between the lines, because they don't just want to look at the pure numbers, which show that they're not unusual, where it says, how many quote-unquote assault weapons and large-capacity magazines must there be to consider them in common use at that time? In resolving that issue, should we focus on how many quote-unquote assault weapons and LCMs are owned, or how many owners there are, or how many of the weapons and magazines are merely in circulation? Do we count the weapons and magazines in Maryland only, or in all of the United States? Must the weapons and magazines be possessed for any lawful purpose, or more particularly and importantly, for the protection of one's home and family? So those are the questions that they presented to try and maybe seem like they're not all that usual. Now, if you didn't know what to make of that totally anti-Second Amendment word salad there, basically what they're saying is that we can't just look at the broad picture here. What are we supposed to do? You know, we're not intelligent enough to see that they're in common use and, well, for lawful purposes. So do we look at just what's in Maryland, you know, this Fourth Circuit case? Do we just look what's in the state? Do we look at how many people actually own them? Do we look at how many they own, or what's in circulate? Like, what number are we supposed to look at for the common use test? We're just not that sure. I mean, you know, half of us went to Harvard and Yale and, you know, graduated with all of these different degrees, but we're not really sure how to look at this. That's kind of what they were saying there. And this judge cited that as, you know, part of why she came up with her opinion. And so again, basically what we have here, if this all boils down to, what it all boils down to, is the judge is saying that they're not protected by the Second Amendment. Now, try and keep in mind, okay, in the original case, the judge said that they weren't protected by the Second Amendment because they were too close to what they were using in the military. So it was a totally different rationale, apparently, back then. So I don't know if that just doesn't apply anymore, and now we've moved on to this test instead. But this judge has now once said that they're too close to what we have in the military. Now she's saying they're not protected by the Constitution because, well, we don't use them enough, and we're not sure exactly how many constitutes in common use. So we're just going to go ahead and say that they're not protected. And that's, again, it boils down to the fact that they don't even need to look at any historical analogs. They don't have to go back to 1791. They don't have to shift the burden to the state. They're going to keep the burden on the plaintiffs because, again, they're not protected. And that is the ridiculousness. That is the nuttiness of what you get out of California these days. Anything that you can do to play games with Bruen, with the wording in Bruen, whatever it takes, to get around things or twist things so that the state will come out victorious in these cases, that is what they're willing to do. It's just pure activism at its finest. So again, another district court judge in the state of California has upheld that ban, and it's just mind-blowing at this point that these people consider themselves judges. Judges are supposed to uphold the rule of law and be completely non-biased. They just go off of the word of the Constitution, and that's it. But that's not how it works apparently anymore. It's about your own personal beliefs and how to get those personal beliefs to the forefront. So I wanted to share that with you guys. Thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.